Welcome to this edition of Go Vote Omaha, presented by the League of Women Voters of Greater Omaha. My name is Sapphire Andersen. Joining us is Professor Kendra Fershee for today's discussion on the Supreme Court. The League of Women Voters is a nonpartisan organization and does not endorse political candidates or parties. The League does, however, take positions on issues. Our purpose is to empower voters and defend democracy. Go Vote Omaha primarily focuses on policy issues, and as a result of our discussions, we hope you will feel ready to navigate community challenges and to stay civically engaged. Today, we are discussing the Supreme Court of the United States, the key decisions we've seen this past term, and what this means for the future. We are excited to be joined by Professor Kendra Fershee, who teaches at Creighton University School of Law. She has an impressive legal and academic background, but she also has experience as a political organizer and is well versed when it comes to the intersection of policy and law. Thank you for being here, Professor.
It's my pleasure.
So to start, this year it seems like now more than ever, people are tuned into the Supreme Court, whether it's the nomination of Justice Ketanji Brown Jackson or some of the key decisions we saw coming out this summer. Why now are we seeing a bigger spotlight when it comes to the court?
Well, there were a lot of sort of unusual political moves surrounding the court with respect to the appointment of justices over the last several years. You had the nomination by President Obama of Merrick Garland, which was blocked by the Senate, by Mitch McConnell particularly, which I think was sort of what we're used to seeing in Washington, D.C. when it comes to the political side of things, and that captures our attention. And then that continued when President Trump was elected, and he had 3 nominations to the court, which is also somewhat unusual. It's just there's been a lot of focus on new justices being appointed to the court, and I think the political shift from a more moderate to progressive court to a more conservative court has also captured people's attention.
And that shift has kind of played a part when it comes to the decisions that we've seen recently, especially coming out this past term. So let's talk a little bit about those blockbuster cases that we were seeing coming out of the Supreme Court this year. And obviously one of the biggest decisions we saw was Dobbs versus Jackson Women's Health Organization, or the case that overturned Roe versus Wade. So what is at the core of the legal decision there?
So the decision obviously has been probably one of the most watched and anticipated decisions that the court has certainly made in modern times, and certainly in my lifetime. That what I think is unusual or sort of groundbreaking about the decision is, first of all, the Supreme Court does not like to overturn its own precedent. Once the court has made a determination on precedent, it typically stands by it. It might change it or adjust it or weaken it or strengthen it, but the cases that the court has decided typically stay sort of on the books. This was a reversal of the court's position, which is one of the things that I think the court tries to avoid in terms of not seeming like a political body. It's a body that believes in the standard of stable legal precedent that we all can rely on. So when Dobbs came along, especially when the decision leaked a couple months early, it became clear that the court was no longer concerned about that, what we call stare decisis, meaning the idea that the law is stable and will continue to stay sort of what we know. And so Dobbs basically said that Roe v. Wade was wrongly decided, and that the basis for Roe v. Wade, which was this idea of a privacy interest that's embedded in, the court said was embedded in Roe v. Wade, in the constitutional amendments, several of them, was not sound reasoning. And so the court said that's no longer a good basis for the law to be determined. Now we say that Roe versus Wade was wrong. There is no privacy right to an abortion in the Constitution, and the states are free to restrict abortion rights as they see fit.
And so when we talk about those privacy rights, there are other types of case law that's been decided based on that privacy right.
Yep.
And that's certainly been called into question as to whether those rights are secured moving forward.
Absolutely.
Can you talk a little bit about how the justices discuss that?
Yeah. So interestingly, this is not uncommon in Supreme Court precedent that you'll have the little battle between the judges. You've got the majority opinion that is signed on by a certain number of justices, at least 5. Well, the 5 agree on the outcome, and sometimes you'll have a dissent or concurrence. Here in Dobbs, we had the court sort of taking a look at the basis for the privacy right when it comes to abortion and saying we no longer believe that there is such a thing as a privacy right to abortion, but the majority said, but don't worry, anything else that we've decided that is based on the privacy right is safe, except that Justice Thomas dissented and said, actually, I don't agree. I don't know that I don't think the privacy right exists in the Constitution, and any of the cases we've decided that rely on that privacy interest are suspect. Those cases are, particularly mostly rooted in similar sorts of rights like the right to contraception. So there were 2 cases before Roe versus Wade that determined, one, that married couples had a right to seek contraception because they had a privacy interest. They could go to their doctor and have a conversation and decide what's right for them when it comes to contraception. And that was a case that was in Connecticut. That Connecticut banned contraception. If you wanted to engage in any kind of family planning in Connecticut, you had to leave the state. And the court said that's unconstitutional. Later, the court revisited the decision to ban contraceptives for individual single people in another case a few years later, and the court said, we said it was a violation of people's privacy rights that are protected by the Constitution for married couples to be restricted. Why would it be any different for individual single people? So the court extended that privacy right for the use of to obtain and use contraception was also protected by that privacy interest in the Constitution. So the next step was Roe v. Wade. Same basis. All of those cases relied on the same exact constitutional principles. So if Roe v. Wade is overturned and the court says we don't like the privacy interest, that really, even though the court said, but don't worry about the other privacy interests that are at stake, we legitimately can worry, I think, that maybe contraception particularly will be next.
I think part of that too is when you talk about the idea of stare decisis, or the idea of precedent being so, in the past or historically, it's been so difficult to overturn. And once we see this kind of change or the shift when it comes to overturning case law, overturning rights that have been in place for a while, there comes that worry of what's next. What's next,
right. So people were raising concerns right after Dobbs was decided, well, really after the leak, sort of on the assumption that that would really be at least similar to the final decision, and it was. The concern was, what about contraception? And a lot of people raised the question of the rights of same-sex couples to marry. That decision, though, in Obergefell was not rooted in the privacy interest that the Roe v. Wade and the contraceptive cases were rooted in. That was more a traditional sort of substantive due process and equal protection decision. So I feel a little better about the court's willingness to stand by Obergefell. But as we said, it's a more conservative court. Certainly Justice Thomas, in his dissent in Dobbs, said basically nothing is really protected anymore in terms of those sort of progressive rights that the court was recognizing starting in the 1960s.
So what really are the implications of this Dobbs decision going forward?
Well, basically, it's hard to say in one sense. One thing we know is the court said the ball's in the court of the states. So the states can make their determinations on what procedures they want to ban, what medical care they want to restrict, and the court said the Constitution doesn't have a role in that. The question is, what happens if a state bans abortion with no exceptions? Meaning, even if the fetus and the pregnant woman will die as a result of an extremely dangerous pregnancy, could a state say that there's no exception for the life of the woman and that they both die? If that goes to the Supreme Court, I think the Supreme Court might say, well, we didn't mean that the states could restrict abortion to that level. Maybe there is a constitutional right to life, right? That you don't have to sacrifice your own life for that of someone else or of a potential person. So I think that the sort of limits around what the court has decided in Dobbs are not yet clear. Because the states, apparently have the ability to decide whatever they're going to decide, and we don't know what that looks like.
And we've seen that even this week with the Kansas decision, with voters in Kansas deciding on whether or not to have a constitutional amendment restricting abortion access.
Right. Well, that was really interesting because the constitutional amendment is already in the Kansas Constitution, and the voters were deciding whether or not to repeal it, and they voted no, overwhelmingly. So this is an interesting shift, even in counties that are very conservative. There was a dramatic difference between how many voters voted for Donald Trump, for example, as opposed to Biden, and how many voters voted to essentially keep the constitutional amendment in the Kansas Constitution. So it was a surprise, I think, to a lot of people how strongly the voters showed up. And there may be that this isn't necessarily as political an issue as we thought. In other words, that more people who are conservative and vote conservative are actually not saying much. And they're voting for conservative candidates, but when it comes to the particular issue of abortion rights, they're actually more progressive than they let on.
Right, and I think with that there's come a greater understanding or appreciation of the value of local elections and state elections.
Yes, they have consequences.
Exactly, and we'll continue to see that.
Yep.
So to move on to a separate case that we saw coming out of the Supreme Court, this also touched on historical tradition in a way, and that case was the New York State Rifle and Pistol Association versus Bruin. And in that case, the court struck down a New York law that essentially said you have to have a justifiable reason or cause if you want a concealed carry permit to be able to carry guns in public places. So how does this decision impact Second Amendment rights?
So that decision has changed how courts are supposed to look at regulations in states when it comes to the rights of gun owners to carry in a particular way. So the concealed carry permits were limited to people who had, as you said, had a reason in New York to have a concealed carry, a concealed weapon. What the court said was, there was a rule, that sort of an analysis in the Heller case that was decided in Washington, D.C., came up through the Washington, D.C. Circuit, and that decision had a particular test that courts were supposed to use when determining if states could restrict gun rights. Bruin changed that test and made it easier for courts to strike down any kind of regulation of guns. And so basically what the Supreme Court said is that a court could look at a state law and say, is this law kind of at the core of what the Second Amendment is meant to protect? And if that law is, then the next question that the court is to ask is, does that regulation invade a person's right to engage with their Second Amendment rights? And in other words, does the state have a balanced interest in the restriction? And what the court did, and this is actually, we didn't talk about it, but very similar to what the court said in Dobbs, but on the other side of the coin, which was, the court is supposed to say, well, is this the sort of thing that states used to regulate traditionally, historically? And if the states typically regulated guns in a particular way historically, then the new regulation is permissible. But if it's a new regulation that is not consistent with historical gun regulation in the state, then it should be struck. Interestingly, a potential problem with that is what the court said that courts should do is look at old rules when it comes to guns, but not the rules with respect to a certain type of gun. In other words, there may be a rule traditionally that you can load your musket in a certain way, right? Or you can only have a certain amount of ammunition for a pistol or a shotgun. And obviously, traditionally, we didn't have AR-15s or AK-47s. So the type of machinery that exists in existence now may be regulated differently than the regulations traditionally would have existed. And so the Supreme Court's determination in Bruin leaves open a really wide door. So if a court's evaluating a state regulation on munitions or a type of bullet, if that type of regulation didn't exist, or that type of bullet didn't exist today, right? Or there's no alignment between the historical machinery, then the answer is, well, it's a new rule, and therefore it's not historical, and therefore there's no tradition of that kind of rule, and it can be struck by the court. So new regulations are going to be extremely scrutinized by courts from here forward. In Dobbs, the court basically said, well, abortion isn't traditional in our laws. Most states didn't permit abortion, post 14th Amendment and in 1865 forward for many years. Therefore, there's no tradition of a privacy right to abortion, and therefore we won't recognize it as a constitutional right. So on the one side, we're looking traditionally to say that abortion was banned. On the other side, we're looking traditionally to say that guns were permitted, and those two traditional sort of bases for the determinations are resulting in the banning of abortion and the loosening of restrictions on guns.
And I think that kind of juxtaposition maybe was really put into perspective because these decisions came out back to back. So on one day we had a decision essentially kind of restricting or limiting a state's discretion with certain rules, and the next day we had the Dobbs decision come out, which kind of did the opposite. So it was a little hard for a lot of people to square those decisions.
Fair enough, right? I mean, what the court is doing is leaning very heavily on this notion that if we didn't do something a certain way 100 and some years ago, then we shouldn't be doing it now. And if we didn't restrict guns 100 and some years ago, then we shouldn't be doing it now. Never mind the fact that we were talking about shotguns and pistols then, and now we're talking about automatic weapons. If we didn't permit abortion 100 and some years ago, which may have been because it wasn't medically safe to do, the fact that we can do medically safe abortions now doesn't change the fact that the court said, well, we didn't used to do it 100 and some years ago, so we shouldn't be doing it now. Or we shouldn't be recognizing a constitutional right to do it now. Talk about, sort of anti-progress. If you're thinking about how do you want to craft your laws, do you really want to look at what we did 100 and some years ago as our only guide? Who was making the determination on these big issues then? Who was in the room? Who were the people who were deciding? Certainly not women, certainly not people of color, We are a society that appreciates and understands diversity better now. And so we had a limited group of people making very limited determinations in a time where we didn't have the scientific or medical advancements that we have now. So backward-looking constitutional rights are likely to throw our system into some chaos for a while until we figure out exactly what the people are going to do about it.
Right. And I think similar to some of what we're seeing currently with the Dobbs decisions and the states kind of vying for how to proceed. With this New York decision, we actually saw the New York State Legislature take action almost immediately after this decision came out. So what kind of trends or what, I guess, can we expect from court cases going forward, and that kind of going back and forth or vying between the legislative side of things and the judicial piece?
Well, this has already started. What's really, really interesting, as you pointed out, in New York, and also I think really what got people really concerned or at least caught the attention of a lot of people for the first time when it came to abortion rights particularly, was the Texas law that made it, put a civil fine essentially, or put almost a bounty on people who helped women get abortions after 6 weeks of pregnancy. Because first of all, that was strange because abortion was constitutionally protected. So it actually put this limit on people's ability to help people get medical attention for something that was perfectly legal to do. And so now that Dobbs has been decided, the state can certainly continue with this notion that an individual who hears that someone had an abortion when she was 8 weeks pregnant can sue the taxi driver for $10,000 for helping her get there, or certainly the doctor or the nurses or any number of people who were involved in that medical care. So we've got this legislative action restricting rights, and the court is going to, the court basically didn't really decide on those. It kept saying, well, we'll just let the law take effect. We're making some decisions with respect to abortion later in the term, which was Dobbs. California, Governor Gavin Newsom did a similar thing in California with gun access, which is the legislature passed and he signed a law that makes it unlawful to produce an illegally created gun if someone sells it or has some sort of helps it get to market. They can be sued, just like the Texas law for abortion. So there's this sort of legislative action that's happening in states on different sides of the sort of political spectrum that I think the court's going to really need to figure out. The Supreme Court's going to need to decide, are we going to allow laws to exist where we can, as individuals, sort of enforce our personal, whatever our personal opinion is on gun rights or on abortion, we can go around suing people for having a role in one of those things. And then the other is the big one that we're seeing is states trying to pass laws that restrict the rights of women to travel over state lines to seek abortion care. That's going to be a big question for the Supreme Court. We have a constitutional right to travel. How are we going to enforce that? Is that constitutional? And if it is, how are we enforcing it? Are we having checkpoints at the state border? Are we questioning women of childbearing age if they are pregnant and where they're going and why? I mean, that's sort of the parade of horribles, the perhaps slippery slope could be something someone might say, like, don't worry about that. That's not going to happen. But that's what we're not sure yet what we're going to see.
And so earlier this year, before these decisions came out, there was a Pew Research Center study that noted that over the past 3 years, the share of adults with favorable opinions on the Supreme Court had declined by 15 percentage points. So how, as a legal scholar and as an academic and as a legal professional, how do you have that conversation with someone who is maybe growing dissatisfied or distrustful with the judicial system?
Yeah. I have always been somewhat of an optimist, and I remain faithful in the belief that the system that we created was far from perfect. In fact, it was inherently imperfect when it was designed, but that it has the flexibility to adjust to reality. And I think the court is right now pulling back and saying, we don't want to sort of progress into current times. We want the Constitution to be read more rigidly. And I think that makes the court, when the court's making decisions to sort of align with that thinking, I think it allows people to think that the court's being political. And we don't want our Supreme Court to be political. We have a political body, and people don't have particularly high opinions of it. You know, Congress is not our favorite institution in American, in our American governmental system. So the more that the court acts like that legislative body, the more distrustful of it we become. So the conversation, I think, needs to be that we actually do need to be involved at the legislative level, that has consequences for who's on the court, and that we should be geared toward putting people on the court who are faithful to the Constitution and our stare decisis system, so that we can have some comfort in the stability of the court and the decisions that the court's making.
And that is a conversation that I know will be continuing in communities across the state and across the country. So that's all we have for today. We want to thank you for taking the time to join us, and then thank you, Professor Fershee, for being here today. For the League of Women Voters of Greater Omaha, this is Sapphire Andersen, reminding you to inform yourself about the issues and the candidates, and at election time, be ready to go vote Omaha.